In this part, we will discuss what may be the various types of contracts. We can classify the contracts into different types based on three different criteria. The first is validity of the contract. Second way of classifying the contracts is based on formation. And third is based on performance of the contract. In this part, we will be examining the contracts based on these three different criteria. Let's first understand different types of contracts based upon their validity. Based upon validity, contracts may be classified into following types. We may have a voidable contract. There is something called a void agreement. Then we may have void contracts, illegal agreements, and then finally unenforceable contracts. So these are five different types of contracts which can be seen based upon validity of the contracts. What is a voidable contract? Section 2 clause I says, any agreement which is enforceable by law at the option of one of the parties but not at the option of other, this agreement is called a voidable contract. Say for example, Mr. X threatens to kill Mr. Y if Mr. Y does not sell his house to Mr. X for ₹1 lakh. Mr. Y agrees to sell the house. Now in this case, since consent of Mr. Y has been obtained by coercion, the contract is voidable at the option of Y, and this will be called a voidable contract. Void agreement. An agreement which is not enforceable by law is called a void agreement. This is an agreement which does not fulfill any one of the essential conditions in order to become enforceable by law, and hence it is called a void agreement. A void agreement does not create any legal right or obligation, and it is considered to be void ab initio, that is void from the beginning itself. The third type of contract in this category is something called void contract. Section 2 clause J defines by saying that a contract which ceases to be enforceable by law becomes void when it so ceases to be enforceable. This is a contract which was valid, enforceable when it has been entered into. Because of subsequent developments, it ceases to be enforceable by law, and hence now this becomes a void contract. Say for example, in the case of an import contract, this is enforceable when it has been entered into, but if subsequently war breaks out between two countries, then the import contract becomes a void contract. So it is a contract which is a perfect valid contract when it has been entered, but because of certain later development, it becomes unenforceable by law, and now it is called a void contract. We are trying to understand types of contracts based on their validity. The fourth type in this category is illegal agreement. Now an illegal agreement is one which is against the public policy, or which is of a criminal nature, or which is immoral. A very important issue related with illegal agreement that this agreement itself is void, and at the same time any transaction which is collateral to this illegal agreement, that is also tinted with illegality, that is this collateral transaction is also treated void. Let's take an example. Mr. Raja borrows ₹5,000 from Mr. Hari, the purpose of borrowing being import of prohibited goods. Mr. Hari the lender knows the purpose of the agreement. The law says this transaction of borrowing money between Raja and Hari shall also be treated as void because it is collateral to an illegal void contract of importing prohibited goods. So not only the illegal agreement by itself is void, but any transaction which is collateral supporting to this main illegal agreement, that subsequent transaction will also be treated as void. The last type in this category is unenforceable contract. An unenforceable contract is one which is otherwise perfect but still cannot be enforced in a court of law due to some technical problems or due to some technical defects into this agreement. Say for example, if the law requires that a contract should be stamped properly, and if the document of contract is understamped, it's a legal agreement, but still court of law will not intervene for its enforceability. The point is this: if that technical defect is removed, the contract shall become a perfect legal enforceable contract. Now let's discuss another classification of contracts which is based upon the way different contracts are formed. Based upon formation, contracts may be classified into three categories. These are express contracts, implied contracts, and then finally quasi contracts. In next slides, we will be understanding each one of these contracts in a bit detail. An express contract is one where the terms of contracts are expressly agreed upon at the time of formation of contract itself. It may be by words spoken or may be by words written. Section 9 of the Contract Act says that wherever a promise is made in words, this promise is said to be express. As against express contract, we may have implied contract also. An implied contract comes into existence by the act of the parties, by the conduct of the parties. Say for example, a bus company is running a bus. Mr. A gets into that bus. This act of Mr. A of getting into the bus has created a contract between the bus company and Mr. A without any spoken or written words. The last type of contract based on their formation is something called quasi contract. A quasi contract is a very interesting concept where the law creates a contract between two parties without any agreement between them. Very simple example can be: a trader leaves the goods at Mr. A's house by mistake. However, Mr. A treats the goods as his own. He uses them. Law says a contract has been created between Mr. A and the trader. Now Mr. A is bound to pay for the goods. So here the contract has been created not by parties but by law itself. We may say a quasi-contract is an obligation which law creates in the absence of an agreement. After understanding classification of contracts based on their validity and based on their formation, let's discuss another categorization of contract which is based on their performance. Based on performance, contracts may be classified as executory contract and executed contract. An executory contract may be further classified as unilaterally executory contract and bilaterally executory contract. What do we mean by executory contract? Executory contract is a contract in which either both the parties to the contract or any one of them is still required to perform its share of obligation. A very simple example may be where Mr. A has entered into a contract with a porter for lifting of 5 bags. Porter has agreed to do the same for ₹100. Right now, this is an executory contract because both the parties are still required to perform their share of obligation. Now, an executory contract may be a unilaterally executory contract or it may be a bilateral executory contract. Where any one party to the contract is still required to perform its share of obligation, this will be treated as unilateral executory contract. As against this, we have bilateral executory contract. In this, both the parties to the contract has still required to perform their share of obligation. And then we have executed contract. It is a contract where both the parties to the contract have performed their share of obligation. Nothing is now remain to be done by either of the parties, and that will be treated as executed contract. Taking our earlier example further, Mr. A has entered into a contract for lifting of his 5 bags. Porter has agreed to do this for ₹100. Porter has lifted the bags. Mr. A made the payment to him. This is now become an executed contract. So, to summarize everything, contracts may be classified based on their validity, based on formation, and based on performance. Based on validity, we may have voidable contract, void agreement, void contract, illegal agreements, and unenforceable contracts. Based on formation, there are express contract, implied contracts, and quasi contracts. And finally, based on performance, executory contract and executed contract. These are various classifications of a contract. Thank you.